We're starting our next panel, and in context of what we heard at the first panel, this will be talking about who's fighting these changes and how. I'm going to hand things off to Joan Card, our moderator, and thank you all for being here, and we're looking forward to the conversation.
Okay, good morning, everyone. Thank you, Alice, for having me and this panel. We are thrilled to be here. My name is Joan Card. I'm with the law and policy firm of Culp & Kelly, and we work on water, natural resources, and environmental law and policy issues. We are panel number 2, obviously. Changes at EPA, Interior, and other agencies. Who is fighting them and how? I think you probably have a sense of what we're going to talk about, but we have an excellent panel this morning of one state official and some NGO perspectives who are working, fighting, and litigating some of the issues. We want to thank the panel number 1 for creating a nice foundation for what our panel is going to speak about. So we will start with Matt Baca. Matt is senior counsel to New Mexico Attorney General Hector Balderas, based in Santa Fe, New Mexico. Next, we will hear from Lissa Lynch. Lissa is a staff attorney in the Climate and Clean Energy Program at NRDC, the Natural Resources Defense Council, based in Washington, D.C. Following Lissa, we'll hear from Megan Zuransky. Megan is executive director at the relatively new Center for Applied Environmental Law and Policy, and they are based in Boulder here. And finally, Peter Zalzal, who is special projects director and lead attorney with the Environmental Defense Fund, and he's also, I believe, with the Boulder, Colorado office. So we'll turn it right over to Matt.
Thank you very much, Joan, and thank you all for having me here today. Before I start, I think my boss wanted me to say thank you to Alice for extending the invitation, and he really wishes that he could be here with you all today. Unfortunately, campaign season limits his travel schedule, so instead you get me. My name is Matt Baca. I'm senior counsel to Attorney General Hector Balderas in New Mexico. A little bit about myself. I'm a graduate of UNM Law School, just to the south of you all. I have been with the Attorney General for just about his entire term. He is finishing the last year of his first 4-year term. Well, hopefully first. I thought I'd talk a little bit today about the state AG perspective on the topics that you all have been discussing. There's plenty of overlap in the actual casework that the rest of the panel, I think, will get into the nitty-gritty of the actual claims and things that are proceeding in those matters. But because there's so much crossover, I thought I might just start with talking about what it's like to be in the state AG's office in this climate, excuse the term. So it's been a sad, frankly, but really interesting time to be an employee in the state AG's office. The Republican attorneys general over the last 8 years sort of set the playbook, as you all are no doubt aware, on sort of litigating and working towards bringing policies that at the time they felt were not effective towards their agendas. And now that the Democratic AGs have sort of picked up that particular torch and run with it. And so we've seen a swath of litigation, as I'm sure you all are aware, in everything from healthcare and reproductive rights to, of course, the topic that we're here to discuss today, which is environmental law and policy. A little bit about the way we got involved. Again, you all are no doubt aware that we actually started off in many of our cases defending environmental policies. The Republican AGs for a lot of it, and then towards the end of the Obama administration, sued to block a lot of effective policy in the methane space, the Clean Power Plan, again, things that you all are no doubt more experienced in than I am. But as we sort of took on those fights, we decided, we'll get involved in these cases, we'll work to defend these laws because they're particularly effective, And in a state like New Mexico, for instance, on methane, obviously we're highly affected by it, the Four Corners area, and so on and so forth. And of course, we're a heavily oil and gas producing state. And so environmental policy is really crucial because we also tend to be sort of a forgotten regulatory space and can end up being a little bit of a dumping ground. So we got involved in these cases to defend what we felt like were effective policies that were brought by the Obama administration, and then quickly saw, as everybody else has seen, the shifting in the tide with the election of President Trump and the attempt to roll back many of those cases, those effective regulations. And so it has been a very busy and a very challenging time for us to approach litigation on the federal level across the country, whether it's in the DC Circuit, the Ninth Circuit, wherever, on all of the issues that we'll discuss today. One particularly difficult issue for us is, it's no secret, I work for a partisan elected who certainly has his own views on what environmental policy should look like, what climate policy should look like. And so he obviously has no problem taking the positions that we take in public cases, but we do represent a politically diverse state. And so as the Attorney General's office, we represent more than one political voice. And so we are engaged in what I would call a sort of balanced approach to involving ourselves and involving the state of New Mexico in these cases. We really look for opportunities to represent the interests of the people, either from a consumer protection perspective or more globally from a health and welfare perspective, because that's the statutory obligation of the Attorney General in most, if not every state. Methane is a particularly good example of that, where as an oil and gas producing state, we lose millions and millions of dollars to wasted methane. So that's a particularly sweet spot for us to come in and litigate this issue and to defend rules both at BLM and in EPA that are not only good for the environment, but would result in more revenues to our school children and the people that are the benefactors of those royalties that come from that wasted methane. So like I said, we really look for these cases because we do represent a diverse political spectrum, and we can't just take a partisan position. And frankly, I think it's not effective for us to get involved in a way that is subject to a simple attack like that. Something like, oh, well, you're just doing this because a favorite attack is that my boss is just sort of at the behest of coastal elites, I think is the terminology that they like to use. And so he just is doing whatever they say. Quite the contrary. As I point out, New Mexico is affected by these issues in profound ways. And so not only do we get involved because of that, but because of the soundness of those environmental policies. A lot of the other work we do so that's the sort of federal level. At the state level, as I'm sure you all are aware, we use creative ways to get involved in environmental policy. We're not a policy-making body, but as the state's attorney, we have a lot of very effective tools for ensuring that sound environmental policy can stand on its own. So, for instance, for the last 8 years, we've been under a Republican administration in the state of New Mexico that has not been very friendly to the environment. And has allowed the petroleum industry to effectively write their rules through our regulatory bodies. So we use methods such as, not wholly unlike what's happening at the federal level right now, methods of administrative law or even things like Open Meetings Act, things like that, to effectively check at least the administration and creation of those regulations to ensure that there's fairness in the process, that the sort of diverse stakeholder group voices are heard, so on and so forth. So we are actively trying to do that, and we will hope to see at the state level a sort of shift with a new administration coming in, and one that would be more environmentally friendly and have a focus on keeping New Mexico clean. But over the last 8 years at the state level, we've been busy sort of trying to do what is now happening at the federal level and just playing defense a little bit. You know, like I said, I think the rest of the panel will get a little bit into the specifics of what these cases look like. You all are aware just from the news media, some of the bigger things that we've been involved in directly that we've been proud to partner with the state of California, particularly on royalties and BLM methane rule, and fighting those good fights. And so I look forward to hearing a little bit more about the nuts and bolts of those cases, because in my role, I work a little bit more in politics and policy than I do in actual litigation. So I don't get into the nitty gritty. I'm aware of it all at the 30,000-foot view, and so it makes me frankly a little nervous to sit in a room like this where all of you have substantially more knowledge than I do about those nuts and bolts. But that's a little bit about me, a little bit about our office, and so I'll pass it on to the next panelist, and look forward to your questions. Thanks.
Hi, everybody. So I brought slides because we're going to cover a lot in this 10 to 15 minutes. My name is Lissa Lynch, and I'm an attorney with the Natural Resources Defense Council. I'm a litigator in our climate and energy program, and so my cases are focused on Clean Air Act, climate, and some energy efficiency and energy policy cases. What I'm going to cover here today is kind of an overview of all of the different types of rollbacks that we're seeing and the legal responses to all of those rollbacks. And so I'm not an expert in all of these cases, so I'll be happy to talk about them and answer questions, but just a disclaimer that I'm by no means an expert on everything that I'm going to talk about here. So over the last year or so, we have seen kind of a variety of different types of ways of rolling back environmental protections. And they can kind of be grouped into 4 categories. And the first 3 of them have kind of occurred chronologically. And so the first one is these withdrawals or delays of effectiveness of prior administration rules that occurred right at the beginning of this administration. And we'll talk about a few of those. Then the next group is stays or suspensions or other delays that were promulgated without notice and comment, and in a lot of cases without any explicit legal authority. And then finally, there are the agency rollbacks that are starting to happen with notice and comment rulemaking. And then finally, there's this sort of set of executive actions that are actions that the president has taken himself that have been sort of occurring over the course of the last year. So starting with the withdrawals and delays, the Priebus memo, remember Ryan's Priebus? Seems like a lifetime ago. But this memo came out on the first day of the administration, and it directed agencies to withdraw any of the prior administration's regulations that hadn't yet been published in the Federal Register, and to postpone the effectiveness of those that had been published but had not yet become effective. And this memo was explicitly not to apply to regulations that were pursuant to a statutory or legal deadline, but as we will see, that was not exactly followed all the time. So we're going to start out with a cute one. This is the only cute thing I have in this slide deck, but this is the rusty patched bumblebee. They are a pollinator. They have lost 90% of their range over the last 20 years and have seen just a precipitous decline in their population since the 90s. That's correlated with the use of neonicotinoid insecticides. And so NRDC has been pushing for a long time to have this be listed as an endangered species and actually sued to pushed that listing in 2014. So finally, a final listing rule listing the bee as endangered was published in January with the effective date of January 11th. And the new administration delayed that sort of under the kind of previous memo directive, and they delayed the effectiveness to March 21st. And so NRDC sued and claimed that, argued that the Fish and Wildlife Service lacked the authority to suspend the rule without notice and comment, and this is all pursuant to a statutory deadline in the Endangered Species Act, so the previous memo shouldn't have even applied to it in the first place. And in the face of that lawsuit, Fish and Wildlife went ahead and let the listing take effect on March 21st. So that was, kind of a win for us. A couple more of these that got put on hold right at the beginning. One is this Mercury Effluent Rule from EPA. And this is a rule that limits the amount of mercury that can be discharged from dental offices from like excess amalgam from dental fillings or fillings that they take out. This puts a limit on the amount of that mercury that can go into public wastewater treatment. It's a really common sense rule. It is supported by all of the major stakeholders, the American Dentistry Association and the wastewater treatment utilities that don't want this stuff in there in the first place. And so that final rule was published in December, and it was withdrawn in January of 2017 in this same sort of batch of regs that were all put on hold right at the beginning of the administration. This was NRDC's first lawsuit against the Trump administration, so we're kind of excited about that. And in the face of that lawsuit, again, EPA reinstated that rule in June, knowing that they were not going to prevail in a lawsuit. And finally, these DOE energy efficiency standards, this was a tranche of standards for a bunch of different products efficiency, so like portable air conditioners, air compressors. And under EPCA, the Energy Policy and Conservation Act, there's this 45-day window after a rule is, after one of these standards is published, before it goes into effect, for any sort of typographical or calculation errors to get corrected. This is not something where actual changes can be made. And so what ended up happening was that the administration just refused to publish the rules at all. So that 45 days came and went, and they were never published. And so a coalition of NGOs and states sued this past summer. And we just got a ruling in this case last month, holding that DOE had breached a statutory duty under EPCA. They called it a clear-cut duty to publish the rule after 45 days. So there's another big win. So moving on to the next sort of phase, after this wave of just putting things on hold, delaying their effectiveness or withdrawing them entirely, we saw a second wave of suspensions or delays that were promulgated under these couple of exceptions to the regular course of rulemaking. So under the Administrative Procedure Act, normally you need notice and comment rulemaking, which we've heard a little bit about today. And that includes delays or suspensions of rules. Those are considered to be substantive changes that need notice and comment rulemaking. So there's this exception to that in Section 553 that you don't need notice and comment when there's good cause. What constitutes good cause has been litigated, and there are some, sort of guidelines. You will see in a couple of these examples that there's been very liberal use of what constitutes good cause. This other section of the Administrative Procedure Act, 705, is a provision that allows for the effectiveness of a rule to be postponed during judicial review of that rule. So if there's a litigation challenging the rule, the agency can postpone the effectiveness before it has gone into effect while that litigation gets sorted out. So that's a pretty narrow exception there. And then there's this very specific provision in the Clean Air Act 307D7B that allows the agency to stay a rule for only 3 months, 3 months only, during reconsideration of that rule. And reconsideration is something that can be granted when a party that objects to something in the rule raises that issue, and they weren't able to raise that issue during the normal notice and comment period. For some reason, there was some kind of notice defect that they didn't know that this was going to be part of this rule, and they didn't get a chance to raise it in their comments, and that it's got to be a central, of central relevance to that rule. So it can't be any old issue. It's got to be an important one. So this is a very, narrow category of types of rules, and it's limited to just that 3 months. And after that, the rule's got to go back into effect. So the area that we've seen by far the most action has been in the oil and gas, methane, and we've heard about that already, and Peter's going to talk about it in detail, so I'm just going to keep going. So another one of these stays, this is one of my cases, and I'm very fond of it, although it is not of interest to most people. So these are Department of Energy test procedures for appliances. And so this is like the rules about how the manufacturer needs to test their product in order to certify it. So DOE promulgated this requirement for the testing of central air conditioners. And that was litigated. The industry that's affected by it, Johnson Controls, is the manufacturer that's primarily affected by this. And they sued, challenging that Obama administration rule in the Seventh Circuit. That case has been put on hold since last year. They've been negotiating, and they just sort of put everything on hold in April, and nothing has really happened. Then DOE went about delaying the effectiveness several times until finally they issued this sort of indefinite postponement over the summer, and they cited that Section 705 provision, which is there's ongoing judicial review of this rule, and so we're going to stay the effectiveness. But they did so 8 days after it became effective, and they did so with only one sentence of justification as to why this needed to be stayed. And so we sued in September, and that case is still ongoing. I am pressed for time, so I'm going to skip over this one, but there's just lots of these. All right. So getting into the actual rulemakings, once we got through this sort of flood of delays and stays without notice and comment, all of which were challenged, now the agencies have started to move into the normal course of things, which is to propose whatever change, delay, suspension that they want, and publish that in the Federal Register, providing notice to everyone, and then accept public comment on whether or not they should do that. This is the way that things are supposed to be done, but this takes time. This takes a long time, and especially if the agency does it right, it takes a very long time because they need to consider every comment that they receive, and their final rule needs to explain why they made the choices that they made and respond to the comments that they got. So this process is, long, and so that's kind of the reason that we saw those other two types of stays and delays, is that they just wanted to throw the brakes on everything and put things on hold while they figured out how to undo them through notice and comment rulemaking. So the big case here is the Clean Power Plan, and Megan is going to talk about this in detail. The reason that the only reason that we didn't see any of those shorter term immediate stays or delays is because, as you probably know, the rule was already stayed in 2016 by the Supreme Court, pending the litigation that has still not been resolved. So now they're going through the rulemaking process to undo that rule, as Megan will talk about. Excuse me. And so now we've got a couple of examples of where the agencies have deployed all of these tactics. So this is the EPA's formaldehyde rule for composite wood products. And so this is like the plywood, particle board stuff made out of that. It limits the formaldehyde off-gassing of those types of products, and they are commonly used in emergency housing and trailers that are used after natural disasters. So the Formaldehyde Act was passed in 2010 in response to a lot of issues after Hurricanes Katrina and Rita, and a 2007 study that showed that a third of FEMA trailers had unsafe levels of formaldehyde. So this is bad stuff, and it's, people are being exposed to it at, one of the most vulnerable times. So the Obama administration put out this rule in December of 2016. Its effectiveness was delayed as part of that Priebus memo, pile of delays. And then in March, they issued a direct final rule and a companion proposal. And so what a direct final rule does is, as long as nobody objects, it just becomes final. But if they get any negative comments, they've got to withdraw the DFR and go through the notice and comment proposal process. And so they did get negative comments. They had to go through notice and comment. And they issued a final rule in September that would extend all of the deadlines until this coming December. So just pushing all of this off. A group of NGOs filed suit in October, and this rule was just vacated. The delay was vacated last month as in excess of EPA's authority under the Formaldehyde Act. The Formaldehyde Act requires them to go ahead and promulgate this expediently, and delaying it exceeds that authority. And then, as Jenna mentioned in the last panel, there's this EPA risk management chemical disaster rule that requires planning for disasters. This case is still ongoing. This is another one where we had that series of the Priebus memo delays, and then a 90-day stay pending reconsideration, because this is a Clean Air Act rule, and then a proposal, and then a final rule. And so they've kind of gone through all of these tactics to delay this rule, and so this one is still being adjudicated, and they just heard oral argument on Friday in this case. So, shifting gears for a minute to executive actions. These are actions that the president can just take himself. Heidi discussed this a little bit in the previous panel, but in December, President Trump issued proclamations dismantling a couple of national monuments in southern Utah, cut the Grand Staircase Escalante Monument by about half, and the Bears Ears National Monument by about 85%. So that leaves, that other formerly protected land open to uranium mining, oil and gas development, stuff like that. The Antiquities Act of 1906 is this, archaic law that grants the president authority to name these monuments and to set aside, valuable natural land in the United States. What these lawsuits that were issued immediately after the proclamations came out argue is that the language of the statute clearly gives the president authority to set aside these areas of land. It does not give him authority to rescind monuments that have already been declared. And that is a power that, only Congress can dismantle these things once they've been named. So those cases are, of course, ongoing. And then finally, we all know kind of what's been happening with the Paris Agreement, that Trump, made this very elaborate declaration that we were pulling out of the Paris Agreement, but that agreement does have this withdrawal mechanism that limits withdrawal until after the treaty or the agreement has been enforced for 3 years, and then will only become effective a year later. That will be in November 2020, and that is, sort of an important date for other reasons as well. Finally, to end on a positive note, one positive note, the Kigali Amendment to the Montreal Protocol is an agreement to phase down HFCs, these super climate pollutants. And that one, as of right now, the Trump administration has not backed away from. And so we could end up seeing implementation of that one by the United States. So let's hope. Thank you. Sorry, that was a lot.
Good morning, everyone. My name is Megan Zuransky. I am, as Joanne noted before, the executive director of the really brand spanking new Center for Applied Environmental Law and Policy, which is located here in Colorado. It's a small team of lawyers looking for ways to support innovation and progress in environmental law and policy. My prior job was in the Obama administration, where I was senior advisor in the Office of Energy and Climate Change, and then in the White House counsel's office, where my portfolio included energy, natural resources, environment, climate, and campaign finance reform for some reason. So you might hear some of the perspective from my prior job as we talk about the power sector and the transportation sector, which are the two largest sources of greenhouse gas emissions in our country. So I'm going to start with the transportation sector. So in 2010, the Obama administration put in place the first ever greenhouse gas standards for vehicles, and at the same time put in place fuel economy standards for these same vehicles under the Corporate Average Fuel Economy Authority, which is exercised by the National Highway Traffic and Safety Administration, part of the Department of Transportation. And this was really a landmark effort to create one harmonized program for vehicles across the country. And it involved both EPA, the Department of Transportation, but also the state of California, because under the Clean Air Act, California has a special authority to do its own standards for pollution from vehicles, which it has had for decades and decades and has been exercising for decades and decades. And often you see California as the vanguard putting in place stronger standards, which then other states are allowed to adopt under the Clean Air Act. And then you often see the federal government sort of catching up and putting in place their own standards. Of course, the automakers hate more than anything having different standards applying to vehicles that they're selling in different states, which is very understandable. So this effort in 2010 was to create one harmonized program, not just for the greenhouse gas emissions from California and EPA, but also for the fuel economy standards under the Department of Transportation. And so the 2012 to 2016 standards were put in place in 2010. Those were then followed in 2012 by greenhouse gas standards that went further in time from 2017 to 2025. As a part of that sort of broader effort to put in place those standards that go through 2025, there was an agreement with the automakers that there would be a midterm evaluation where EPA would look again at the standards and by April 1st of this year would decide whether or not the standards still looked achievable based on technology developments that had happened in the interim. Those standards, the way that they are designed, there was a strong effort by both EPA and the Department of Transportation to make the standards flexible. And so you have the design of the standards are based on what they call footprints, which reflect a group of vehicles that are about the same size. So you have one level of standard applying to the smaller cars, another level applying to the sort of medium-sized cars and what they call light-duty trucks, those small SUVs, and then you have a third footprint for the bigger, the real trucks. And there's averaging and of credits and effort to give manufacturers credit for the things that you don't see in the tailpipe, like when they reduce emissions of HFCs from the air conditioning units in the vehicles, which are also very powerful greenhouse gases. So a real effort to try to make sure that you were encouraging everyone to develop standards or develop vehicles that are going to reduce greenhouse gas emissions as cost effectively as possible. When these standards were put in place, the projection of their benefits projected that there would be $1.7 trillion in savings by consumers because they are paying less money for gas. 12 billion barrels of oil saved over the lifetime of the 2012 to 2025 model year vehicles, 6 billion metric tons of carbon dioxide eliminated, and $8,000 that your average family would save over the lifetime of one of these vehicles. Now, those predictions are predictions, and choices that consumers make if they buy bigger vehicles than everyone expected, if they drive more, et cetera, like, you know, those benefit assumptions are going to change, and gas prices have a lot to do with that. But the fact that these standards are massively beneficial relative to their costs is going to be consistently true. So to go back slightly in time, the Obama administration started this process of the midterm evaluation, put out a technical assessment report that was this massive evaluation of where technologies were actually at in the spring of 2016. There was a comment period, folks commented on that, and then they actually finalized the midterm evaluation right before leaving office and found that the standards were still achievable, and that in fact, if you looked at the changes in technology, it was going to be cheaper to get to the level of the standards than had originally been predicted. The Trump administration came in and decided to reopen that midterm evaluation, and that is the process that we've been engaged in. There was a comment period, and what we are waiting for, probably sometime around April 1st, is a new decision about what they're going to do in terms of finding whether or not those standards are still feasible. If I had to gaze into a crystal ball and predict what's going to happen, it's possible that the crystal ball would say that they're probably going to find that the standards need to be reevaluated. At that point, we will go into, as Lissa described, a new regulatory process. They will put out a proposal, there will be a comment period on the proposal, they will then finalize standards, and then we will probably get back into the realm of litigation. The litigation, for the lawyers in the room on the car standards is going to be largely about these very in the weeds questions of what do these technologies deliver, at what cost, and are they, beneficial? It's going to be a really sort of engineering, weedy bout of litigation. But that's something to look for coming up, which of course calls in question the role of California. So California has their own standards through 2025. They have a waiver from EPA to have those standards. The Trump administration, especially Administrator Pruitt, has been doing some saber rattling about the California waiver, saying things like California, cooperative federalism doesn't mean that California gets to dictate to the rest of the country what their standards should be, et cetera, et cetera. So again, if I had to gaze into a crystal ball, you might expect the administration to go after the California waiver. EPA's authority to grant a waiver does not include, at least as clearly stated in the Act, the authority to withdraw a waiver that has already been granted. It's also never been done. So if they do attempt to go after the California waiver, there will of course be litigation over whether or not they even have the authority to do that and whether or not the grounds on which they decide to try to attack the waiver are actually valid. So that is another set of litigation to watch out for. I'm going to take one brief detour from the greenhouse gas world to note that something else to watch for in the context of the transportation sector is a rule on what they call gliders, which probably nobody knew about until recently, but you should all understand what they are. Gliders are vehicles where you take an old engine for a semi, like big trucks, and you put it into a new vehicle. Why would you do this? You might do this because you're recycling, right? This old engine still has some capacity to it, but the rest of the vehicle needs to be updated. Another reason you might do it is to avoid the emission standards that apply to new trucks. The glider industry used to be very small. Once there were pollution regulations on these big trucks, that industry suddenly became quite large. There might be a connection between those two things. EPA put in place a rule to address the emissions from these vehicles, which are 40 times what you will see from a cleaner, modern truck that is meeting the current air pollution standards. And the type of pollution we're talking about here is, of course, greenhouse gases, but it is also the traditional types of pollutants that we were used to thinking about before we started understanding what greenhouse gases were, so including particulate matter, NOx and SOx. These are very, very dangerous vehicles in terms of the amount of these pollutants that they're putting into the air. The Trump administration decided to revisit the glider rule and put out a proposal to pull it back, asserting that they lacked the authority, arguing that these were not new vehicles because they have the old engines in them. If you sort of take yourself down a little logical, walk, you can think about, if that is true, what that would mean. That would mean you could put all kinds of old things into a vehicle and suddenly it's no longer new, right? So like the vehicle, it has a steering wheel that's been used before, so now it's no longer a new vehicle. The other problem with this argument is EPA has authority and an obligation to regulate rebuilt vehicles and existing engines that are used that are still being used. So there's plenty of statutory authority to go around. They're still trying to yank this proposal. We'll see yank the rule. We'll see what actually comes out as a final rule. I think if they're smart, they will never finalize the attempt to repeal this rule because that one is not going to do well in court. Okay, so leaving the transportation sector, moving on to the power sector. The Clean Power Plan, which probably most of you know all about, but I will try to quickly summarize. These were the first ever greenhouse gas standards for existing power plants in this country under the Federal Clean Air Act. The big question that you face under this part of the Act, which is Section 111D of the Clean Air Act, is what is the best system of emission reduction, that is the statutory language, for this sector and this type of pollution. So EPA looked at the power sector and they looked at greenhouse gases and they said, what we're actually seeing on the ground in terms of what companies and states are doing successfully to reduce their emissions is they are switching from higher emitting sources of electricity generation to lower emitting sources of electricity generation. So that's what EPA said was the best system of emission reduction, going from coal and gas to renewables and from coal to gas. They also said you should tinker with those coal plants and make them more efficient. So that was the best system of emission reduction. EPA then looked at what you could get in terms of emission reductions by applying that system across the different electricity grids, and then came up with a state-based emission limitation that states could meet in 3 different ways. They could do a rate-based trading program, where you're doing pounds of emissions per megawatt hour, where you've got credits for increases in the lower emitting generation. They could do a mass-based trading program, which is a cap and trade program, where you just limit the amount of tons that are overall emitted. Or you could do some other framework where you were going to get those emission reductions and you could show EPA that you were going to get them from some other set of state policies. EPA's original analysis found that the Clean Power Plan would reduce greenhouse gas emissions by 32% from existing power plants by 2030 over 2005 levels, and deliver $20 billion in climate benefits and $14 to $34 billion in other air pollution benefits annually when it was fully implemented in 2030. So the net benefits, cost benefit analysis, would be 26 to 45 billion annually. Very, very beneficial policy. There was, of course, a legal challenge. You will not be surprised. This went straight to the DC Circuit, which is what happens with federal rules under the Clean Air Act. There was a 3-judge panel evaluating an initial petitioner from the challenges to stay the rule. The 3-judge panel looked at thousands of pages of briefing material, rejected the stay petition. It went up to the Supreme Court. As Lissa said, the Supreme Court, after I think having the papers for 2 business days, the final papers, issued a stay of the Clean Power Plan. It was, I believe, the second to the last action that Justice Scalia took in his work life. We then went back to the DC Circuit for the merits argument. The DC Circuit, sua sponte, on its own motion, took the case en banc. So this was argued in September of 2016 before the entire complement of DC Circuit judges. The argument went on all day. It was an amazing sort of event if you're a lawyer and you like these sorts of things. Argument, I think most people would say, went quite well for EPA and the Department of Justice and all of those supporting the Clean Power Plan. Then there was this election thing that happened. We're still waiting for that decision. So the DC Circuit has not yet issued its decision. They seem to not have enough votes to do anything with the Clean Power Plan, either send it back to EPA or put the case in abeyance, which is basically putting it on ice, or issue a decision. They just seem to be split between themselves. So then we get to the Trump administration. They are not huge fans of the Clean Power Plan. They issued a proposed revocation of it. The legal theory here is not particularly interesting because it is a repeat of everything that was argued in that litigation. The argument is the best system of emission reduction can't include generation shifting, the shift from the higher emitting sources to lower emitting sources. It has to instead be things that you can do at the plant itself within the fence line is the usual sort of shorthand for this. And they also object to the fact that the Clean Power Plan will have impacts for state energy policy planning, which of course any federal environmental regulation has impacts for state energy policy planning, but that's their argument. So the legal arguments we're seeing in the proposed revocation are not at all surprising. What is surprising and what is worth taking a look at is the regulatory impact analysis that looks at the costs and benefits of the Clean Power Plan. As I noted before, the benefits are massive. They're not massive anymore when you look at the new regulatory impact analysis, and this is mostly for three reasons. One, as Lissa noted earlier, they are no longer using the social cost of carbon, which is an assessment of the cost to society that a ton of greenhouse gases causes when it is emitted. There was a federal task force that involved lots of experts from the federal government that put together a social cost of carbon and then continually updated it. That has been disbanded. And now they are using what they are calling a domestic social cost of carbon, where they're ignoring the impacts in the rest of the world, which might make sense except for the fact that we are affected by climate impacts that happen to other countries, given the interrelationships between our economies, national security, all of these sorts of things. They're also using a very high discount rate, which sounds really boring, but is very, very important because a lot of climate change impacts happen far into the future. So if you use a discount rate that is higher than what experts recommend, the world can basically end in 300 years, and it shows up as a couple of pennies today. And you think I'm exaggerating, but I'm really, really not. That is the power of, this is why we should all invest. It's very beneficial for your retirement account. It's not very good when you're talking about how we evaluate today impacts that are happening far, far into the future to other generations who, by the way, don't get to vote today. Social cost of carbon was one issue. Second issue was energy efficiency and the way that that is looked at in the regulatory impact analysis. Again, sounds boring, but stay with me. When you look at the cost of an air pollution rule, what you do is you run a model of that sector with the standards in place, and then you run that model again without the pollution standards in place. And you look at what that model tells you the operating costs of that sector are going to be. You subtract one from the other, and that's your compliance cost assessment for that rule. When EPA first modeled the Clean Power Plan, it was very clear that investments in energy efficiency were going to be one of the cheapest ways to reduce emissions. Because when you reduce the energy you use, you don't have to pay to create that amount of energy. So it's a very cost-effective way of reducing emissions. What EPA did in the new analysis of the Clean Power Plan is they took that amount of electricity that was not going to be generated under the Clean Power Plan, projected how much it would cost if you did produce that electricity, which is billions of dollars, and then added that number to the costs of the Clean Power Plan, and then added that same number to the benefits of the Clean Power Plan. So your net between your costs and benefits is exactly the same, but now you've got a really big cost number to talk about, which may or may not be why they did it. The third thing that they did, which is less funny, is what they did with particulate matter. So PM 2.5, this is the really tiny, tiny particulate matter. The Clean Power Plan would have reduced particulate matter very significantly. EPA ran sensitivity cases in the regulatory impact analysis where they put to zero the benefits from reducing particulate matter below the level of the ambient air quality standard for particulate matter in one sensitivity analysis, and put it to 0 below the level of 2 studies that looked at specific levels of particulate matter and the harm that they caused that were also used in the sort of to assess what kind of harm particulate matter causes. By doing this, the RIA artificially reduces the benefits of the Clean Power Plan by somewhere between $5.7 to $15 billion in 2025 and $9.4 to $29 billion in 2030. This is not scientifically supportable. The World Health Organization, all of the other national health organizations, the American Lung Association, who we will hear from later, any scientific body will tell you that there is no evidence that there is a threshold below which exposure to particulate matter does not cause health harm and premature mortality, because that's what it does. It exacerbates respiratory illness, asthma, lung development in children, and causes premature mortality. And EPA has just wiped out those costs to people and therefore the benefits of reducing that pollution in these sensitivity cases, which I think is tragic. Yeah, yes. So then just to finalize sort of the step of where we are, they have also come out with an ANPR, an announcement of proposed rulemaking, which is exploring ways in which they might replace the Clean Power Plan. The announcement of proposed rulemaking focuses on heat rate improvements at coal plants as what you would do, which will get you very, very small emission reductions and possibly emission increases, because if you increase the efficiency of a coal plant without doing anything else, that plant may well run more often because it's more fuel efficient, which could increase your overall emissions. They do not look at any of the other things that you might do, including co-firing with gas, conversion of coal plants to gas, carbon capture and sequestration, or simply reducing utilization of higher emitting sources. We're expecting to see a proposal pretty soon following that announcement of proposed rulemaking, and then, we will have a final rule potentially, and then we will again enter into the cycle of litigation.
Good morning. My thanks as well for the opportunity to be here today and to talk with you all about litigation during the Trump era. As Joan said, my name is Peter Zalzal. I'm an attorney with Environmental Defense Fund, and I work on our U.S. Clean Air team. And so as part of that work, I focus on major sources of emissions of greenhouse gases and criteria air pollution, and policies that we can put in place to reduce those harmful emissions. And so one of those sets of policies that I've done quite a lot of work on over the last really 6 or 7 years are policies that relate to emissions from the oil and natural gas sector. And as it so happens, those policies have also been the subject of quite a lot of litigation over the course of the last year and a half. Lissa touched on some of that litigation, but I'd like to spend a little bit more time talking about some of the cases that we've seen, some of the commonalities across some of those challenges, and then some of the key takeaways that we've had from those legal efforts. And it's hard to overstate how much litigation has happened in this space. We're going to try to talk about each one of these generally, and then leave some time for questions at the end. So as others did, I want to start just with a little perspective and to set the stage about some of the actions that we're talking about and how they were developed and put in place. So there are really two that I'd like to focus on. The first is EPA's standards for methane emissions and volatile organic compound emissions from new and modified sources in the oil and gas sector. So these standards were put in place in 2016. There were earlier set of standards that were put in place in 2012. And what they do is they require technologies and best practices to reduce emissions from new sources, newly drilled oil and natural gas sources. They're based on techniques that we know work. As presenters earlier this morning indicated, they're really designed based on the standards that Colorado has in place, similar standards that Wyoming has in place, and industry best practices that have been pioneered over the course of the last decade and a half. And they're really important. They'll reduce methane emissions by 510,000 tons in 2025, reduce smog-forming emissions as well, and toxic air pollution. The other policy that I want to touch on is BLM's standards to reduce natural gas waste on federal and tribal lands. BLM adopted these standards under different legal authorities, so that agency is focused on the minimization of waste of public resources on public lands. Those standards address both new sources and sources that are already in existence. So in that sense, cover a broader spectrum of sources, but they're really designed to minimize the waste of natural gas, and as a result of that, also reduce harmful air pollution. And as it happens, many of the same things that reduce air pollution also reduce waste, so there's overlap between the types of standards that EPA and BLM adopted. So that's where we were. Those standards were developed over the course of really 5-6 years with significant public input, really highly developed records, and a lot of stakeholder engagement. With the shift of administration, the Trump administration indicated its intention to roll those standards back. That was first expressed in an energy independence executive order, in which the administration indicated, specifically directed both EPA and BLM to look at and potentially rescind those actions because they, quote unquote, burden domestic energy production. And then so both agencies embarked on an effort to rescind those standards that I think has largely reflected 3 different pieces. And Lissa touched on these earlier, but the first is an effort to suspend the standards immediately without notice and comment, without any public input, without any process. So that was sort of part 1. Part 2 was to again suspend the standards, but this time through a notice and comment process where they did seek public input on that suspension. And then the third part of the anticipated approach here is kind of a rescission, a substantive rescission of the standards, and we haven't yet gotten there for many of these actions. So part 1 and 2 have engendered legal responses from both public health organizations, environmental organizations, and many states. And I want to talk about three cases briefly there. The first is an action EPA took in April of 2017, in which they indicated, the administrator indicated he was going to grant a reconsideration petition. Several industry groups had asked EPA to reconsider certain aspects of the standards, and then also to issue a 90-day stay of those standards under purported authority that EPA has in the Clean Air Act. So the administrator did that on June 5th. This was 2 days after the standards required compliance, but the action retroactively made the suspension effective to before compliance was required, issued that 90-day stay. As I said, there was a coalition of health and environmental groups who filed a legal challenge on the same day that action was published in the Federal Register and asked the court to block it or to summarily vacate it because it was inconsistent with the agency's statutory authority. Similarly, there was a broad coalition of states that filed a legal challenge in the action as well, and these include significant oil and gas producing states like New Mexico, Colorado, and Pennsylvania. And before we get into, I think, some of the legal takeaways, which we're all very interested in, and the nuts and bolts of the Administrative Procedure Act is great. I think it's important to remember why we bring these actions, because they affect people, and because removing these protections results in a lot of additional air pollution. That's not something EPA looked at when it did this, and that's one of the legal deficiencies of the action the agency took. But we looked at it in the context of our legal filing and found that if EPA's suspension of these standards were allowed to stand, 18,000 new oil and gas wells would not have to take common sense actions to reduce pollution during the pendency of the stay. And that would mean lots of additional smog-forming pollution and toxic air pollution in communities across the country. So what happened in court? We filed our action on June 5th. On July 3rd, and it was an emergency request for relief given the short time period. On July 3rd, the Court of Appeals for the D.C. Circuit vacated EPA's suspension as unlawful. 3 things I want to highlight about the decision and their commonalities across each of the actions. The first is the court found that the agency lacked legal authority to do this. So EPA had said, we have broad authority to issue suspensions, even if we don't have broad authority, we have specific authority in this provision that Lissa highlighted earlier, Section 307 D7B of the Clean Air Act, which allows a very limited stay of agency actions if certain conditions are met. And the court simply found that there was neither broad authority to do this nor specific authority under this provision. The second thing to highlight is that facts matter, and a number of presenters have indicated this, and agencies can't make them up. So here, EPA had said, well, we can state these standards because the specific issue here is one that, people didn't have an opportunity to comment on during the context of the rulemaking. If you looked at the rulemaking, it was expressly clear that the issue was raised, and in fact, the very people that were involved in the litigation had actually commented on it, and EPA had made changes to reflect that. So the agency's position was simply inconsistent with the facts, and that's one of the reasons that the court held that it was unlawful. And the third thing to highlight here is that public input matters and process matters. So one of the things that the court faulted the agency for not doing is going through a public notice and comment process. So after that decision, there were a flurry of petitions for rehearing en banc, asking the whole DC Circuit to reconsider this decision. All of those were denied, and since that point, the standards have been continued to remain in effect. BLM has taken a similar approach to trying to suspend its standards. Shortly after the EPA litigation happened, BLM suspended the waste prevention standards, again, without any notice and comment. The agency relied on a different provision of the Administrative Procedure Act, provision that's known as Section 705, that allows agencies or courts to suspend an action. Two important features of the provision. One, the language allows the agency to postpone the effective date of an action. And the second important feature is that it's pending litigation. So again, there was a legal challenge here from health and environmental organizations and also the states of California and New Mexico because we felt that the agency had not acted consistently with that statutory authority. Some of the key takeaways from the litigation are the same. There are some commonalities with the EPA litigation. The first is the court found BLM did not act consistent with its statutory authority. So two important pieces here. The first is the rule was already effective. So you can't postpone the effective dates of a rule that's already effective if that's the statutory authority you're relying on. And second, the agency was doing this purportedly to enable it to reconsider the standards, not to allow litigation to proceed. They actually tried to stay the litigation. So the court found that the authority that BLM was purporting to rely on just didn't fit, and the agency was acting outside of its statutory authority. The second, again, is that facts are important, and one of the things that the court here found to be particularly troubling about BLM's suspension was the agency considered the cost savings that would accrue as a result of the suspension, but failed entirely to consider what the impacts on the public would be, what the impacts associated with the waste of natural gas would be. That sort of one-side analysis, I think, what the court found is really the hallmark of arbitrary and capricious agency decision-making. And the third, and again similar to the EPA litigation, is the agency didn't take public input here, and that was a serious deficiency that the court found. Sounds good. I will very briefly touch on the second wave of suspensions. So after both of these suspensions were invalidated, the agencies again tried to suspend the standards, but this time through a notice and comment rulemaking, and that was really the only difference. So this time they asked for public input on the suspensions, but otherwise offered some of the very same reasons that had previously been rejected in the courts. So EPA has not yet completed that process, but BLM did finalize a suspension rule that would extend the compliance deadlines for the waste prevention standards for a number of years. We filed a legal challenge to that, as did the states of California and New Mexico, again, because we felt that it was inconsistent with the agency's authority. And here, there are a little bit different legal issues at play. Agencies, as folks have said earlier this morning, can change positions, but those changes of position have to be grounded, one, in the agency's statutory authority, has to be consistent with what they can do in the statute, and two, has to be consistent with the factual record and the explanations there. So what BLM did here was to change the standards under the waste prevention rule. The reasons that BLM gave were that it didn't want costs to be incurred while the agency was reconsidering the standards, and thought that the standards were unworkable, infeasible, and were overly costly and burdensome for operators. The problem was the facts in the record were exactly the opposite. So the facts that BLM had and had to explain showed fairly modest costs. And at oral argument, the counsel for the government was even asked this question of, do you have any factual support for the assertion that these particular standards are unworkable? And the answer was no, there's nothing in the record. So in that sort of a context, the court found that it was simply arbitrary for BLM to reverse position. And one other thing just to briefly note here is that the agency did ask for notice and comment on the suspension, but limited that, did not accept comment on the substantive issues that it said were problematic with the rule. So even though it had gone through the sort of steps of doing this, the court found that it wasn't sufficient because really the agency had tried to limit public input. So there's more to be said about all this, but four takeaways that I have from this litigation. The first is back to a point that I had made earlier about why we do all of this. The environmental benefits of keeping these standards in place are really significant, and fortunately, both sets of these standards, yet from our perspective, remain in place. So on the EPA side, there's now over 30,000 wells that are subject to these requirements, just because new wells are being drilled constantly, and the standards are in full force in effect. And on the BLM side, over 100,000 wells are required to take these actions to ensure they're minimizing waste and also reducing pollution. The second relates to an important legal principle, which is, agencies can change position, but if they do that, the change has to be grounded in their statutory authority and a reasonable explanation. I think through all of these cases, what we've seen is that, courts won't allow agencies to shortcut that and to, call something a suspension, to try to cast something in a different way and to get around those really fundamental requirements of changing position. You can't skip those steps. The third is that facts matter, and that's on three levels. The first is that there are really significant factual records that underpin each of these rules. They were developed over the course of many years, and they're important because they're the basis from which agencies have to explain any changes in position. The second is that agencies changing position actually have to identify facts that support that change and explain to the public why they're making that change. And the third is that, from the standpoint of a health and environmental organization, facts matter for us as we're bringing these challenges. Taking a step back, one of the things that we found particularly troubling is both that agencies are reversing positions on policies that we think are really important, but also that they're doing it in a way that, from my standpoint, is intended to avoid judicial review. So a very short suspension, another suspension, and another change. And unless, as a litigating organization, you're able to seek from a court emergency relief, which requires substantial factual showings, those suspensions may just be able to go through because of their duration. So we've had to develop the facts that demonstrate how problematic each of these actions are, and that's been a key feature of all of our legal challenges. And the fourth takeaway is one of opportunity cost. So I think even here, where we and others have been successful in opposing some of these rollbacks, there's been a significant amount of resources devoted to litigation, and litigation that's sort of meant that we're in the same place that we were a year and a half ago. Jill mentioned earlier this morning the idea of innovation. There's a number of projects that EDF is focused on in partnership with a lot of different people in this room on developing innovative technologies to improve even further our ability to monitor emissions from the oil and gas sector. Those are reflected in EPA and BLM's current policies, and there's ways to improve those policies to make them more effective. Spending this time opposing what in my view is reflexive efforts to roll back protections means we can't spend time working towards solutions where I think we have a lot of commonality with a number of different stakeholders. So we hope that'll change going forward, and thanks, and look forward to questions.
Great. I want to thank all the panel members. Are the mics on? Do I need to push something? Is the mic on?
Yes.
Great. Sorry about that. I want to thank the panel members for the impossible task of trying to overview all of the activity in such a short period of time. We really could do a 2 or 3 day conference just on this material. I noticed that they didn't have a chance to talk about the Clean Water Rule on their outlines, EPA landfill policies, ozone implementation. So there were a number of things, a Keystone Pipeline that we could talk about and just didn't get a chance to talk about. We do want to be on time for lunch, at least as on time as we can be, but I thought we'd have a quick little panel discussion following up on a couple of items and then maybe 1 or 2 questions from the audience if we have time. So lots of conversation in this panel, or reference on this panel and a little bit on the prior panel to the Administrative Procedures Act. I wanted, and Megan, you hit it pretty hard with respect to your topics, and Peter talked about it. I wanted to give maybe Lissa a chance to talk about the role of the agency record review, and some of the litigation she's working on briefly. But also, if you have a particularly informative or insightful or entertaining story about the administrative record, any of your cases, I'd be interested, and I think folks would be interested in hearing what you've learned from a record in the record in any of your litigation. So, Lissa, any lessons learned on APA or insights on APA in your work?
Well, so I think one of the really interesting things about kind of all of what we've been talking about is something that Peter touched on right at the end, which is that a lot of these short-term actions seem designed to avoid judicial review, and that the way that the APA and this rulemaking process operates is by requiring a proposal, an opportunity for public comment, is you're building this record on which the final thing needs to be based. And then once there is a final rule, that's when litigation can start. And the litigation has to be tied back to things that were raised in the record, or for a notice type challenge for things that didn't have a chance to be raised in the record. And so the notice and comment process is directly tied to, the building of the record, and then that is the foundation of what litigation can and must be based on. And so when you take these short-term actions, you're sort of trying to circumvent that foundational system. Does that answer your question?
Yeah, no, I think that's great. And Peter, you kind of chuckled when I asked for an entertaining story about the record in any of these cases you're working on.
I'm sure there are a number of them that are not coming to mind right now, but one actually relates to one of the last points I made about sort of these issues, like whether these issues were raised as part of the underlying notice and comment record in the rulemaking. And one of the funny things about this is, like, actually some of the industry parties that were on the other side had indicated that, yeah, they had fully been raised and these weren't appropriate, issues for the agency to kind of rely on in this manner. So for some of this, I think there's pretty broad recognition of, like, what the facts are, but just not something that the agency is following.
I think we forget, or we talk a lot about these being agencies, but they're agencies full of people, right? And so we had people, the same people, working in the agencies and at DOJ on these Obama-era policies who are now defending these Trump administration actions. And I'm sure you're steeped in working with these people who are maybe feeling a little bit of whiplash about these changes that are happening.
Well, so just
yes,
on that
Megan.
point, though,
Yeah.
I think one of the things that you see from the documents that are coming out of this administration, the career civil servants in these agencies have tremendous expertise, legal and technical, and they are used to building records and engaging with facts. From what you hear via the rumor mill and from what you see coming out, they are not actually engaging their career staff effectively in most of these rulemakings. I mean, you can read these documents and I can say like, oh, that paragraph was written by a real EPA person, and then the next three were written by a political appointee, and not a political appointee who knows what they're doing in terms of the record. So their failure to work with their career staff, which are just a tremendous resource of professionalism and expertise, is leading them to put out very poor proposals and rules, and I think we'll continue to see that if they don't change.
Okay, so a lightning type round on forecasting future activity and future litigation. Matt, do you want to engage in that?
That's tough. You know, I think as some of the panelists pointed out, a lot of it isn't necessarily picking a new issue. It's really seeing the substantive evolution of the issues that we're already working on. I think as Lissa pointed out, a lot of this is just in the sort of preliminary phases, and we haven't even started, you know, the actual litigation of these issues. So I don't know if I have a substantive prediction for you, but in terms of the next year and a half or so, obviously we're going to see a lot of this stuff really actually start to come to fruition.
Lissa, do you want to name a couple you're watching for?
So one of the things that we haven't touched on at all are the failures to perform statutorily required obligations of the agency. And so I think in the next couple of years, probably starting relatively soon, you can expect to see NGOs or states bringing litigation to force the agencies to do the things that they are required to do. So, for example, there are, you know, statutory or regulatory time requirements for promulgating, you know, state plans or things like that. And this administration is, you know, clearly failing at doing any of those things. And so that's an area where litigation will start to take off probably soon.
Megan, do you want to add to that?
So I know you're curious about the endangerment finding for greenhouse gases. I think that one's really hard to predict because there are clearly forces within the administration who would like to go after the scientific finding that greenhouse gas emissions endanger public health and welfare that was made in 2009 at the beginning of the Obama administration after the Massachusetts versus EPA Supreme Court case. I think Administrator Pruitt is one of those people who would probably like to go after it. I think there are other forces within the administration who have so far prevented that, who are probably listening to lawyers telling them that that is a loser from the beginning to the end. But it's very hard to predict with this administration where those kinds of dynamics are going to work themselves out. And as we see more and more people leaving the White House, the voices in the room are changing. And so that may well change what happens in these outcomes.
Peter?
So yeah, I think we're at an inflection point. It depends on the way that the administration goes. If the administration continues down the path of trying to, you know, rescind and get rid of some of these core protections, I suspect that, you know, litigation over those issues will continue. You know, for instance, if we see a rescission rule on EPA standards for the oil and gas sector, but if we see a different approach, then we might see a different outcome.
Oh, great. So maybe one or two questions of general interest. Alice, there's several people raising their hand.
If you guys promise to be back here at 1:15, we can go a little bit longer. How's that? In your seats. No, I don't have to yell at anybody. And are there any students in here that have questions right now? Because we always, okay, they're in class.
In terms of the fact that facts matter, I'm curious to know what NGOs think in the legal end of how the record is doing. Certainly, if you don't respond to comments in a substantive way, there's no way for the commenters to turn around and say, yeah, but remember when I said this later. And on the scientific side, one of the easiest ways to restrict new restrictions based on best available science is simply not to have any. And in Canada, huge losses were done to federal documents under Harper. And I'm curious to know if you guys have repositories of what you're referring to in the record, or if there's ways beyond just simply the superficial websites that are being altered, or if we really know that that documentation is sacrosanct.
So that's a big question. There are the records that we are talking about are closed records that were created for specific rules, and those are, you can't get rid of those. They're sort of litigation documents. I think the harder question is what happens to all of the underlying data and research that federal agencies have been working on and developing for years and years and years. And at the very beginning of the Trump administration, there was a massive effort to download and save lots and lots of data from lots and lots of government websites. Those efforts have continued. How it's all going to sort of work itself out over time, I don't think we know yet, but folks are definitely trying.
I saw a hand in the back. Do you still have a question? Oh, or right there.
Well, McClure, I understand this conversation is largely on policy, and I understand the reasons for that. I have a specific question, however. I've recently, I think High Country News has covered this very well, the topic of hundreds of abandoned, orphaned wells throughout the state, where companies are either declaring bankruptcy or just walking away, leaving wells that are not properly capped and closed. Do you have any comment about what kind of regulations might bear on that?
I believe that's mainly a state issue. Matt, New
Sure.
Mexico experience on that?
Yeah, absolutely. So through our Environment Department and at the State AG's office, we have statutory authority to pursue enforcement where there's an obligation to close and or plug abandoned wells. I don't know what the state of enforcement here is. I can say that in New Mexico, because of a combination of some Supreme Court precedent that effectively gutted some of the enforcement authority at the Environment Department and what you might refer to as a sort of systematic underfunding of those enforcement efforts, we've really suffered a lot of consequence from that very problem that you're discussing. So our office uses the resources that we do have to go after some of the worst, so to speak, and look forward to an opportunity with a new administration and a more diligent approach to addressing that particular issue.
Okay. Looks like, hey, hi, Kate.
Hi. I realize the title of this involves, what to do, how you're fighting the Trump administration. I would be curious to know if your organizations are also sort of looking, or parts of your organizations looking toward the congressional side, because there are efforts obviously underway to deal with some of these issues from all perspectives legislatively, and I would assume some of the groups here are looking at that too, and are you marrying some of these efforts with some of those long-term strategic efforts?
Some heads nodding.
The short answer is yes. At least in the climate and clean energy, section of NRDC, we have kind of a crack team of government affairs folks that we work very closely with, and they work very closely with their champs on the Hill who really care about these issues. And you're right that it is a broader group than just who you might think of, the Democrats. But there are, folks that have the problems in their states that care a lot about fixing some of these issues and recognize that if the administration is not going to take their delegated authority, then Congress can do something about it and should.
Peter, do you want to talk about EDF's work legislatively, or are you involved in that?
Yeah, we are also as well, and I think it gets sort of to one of the last points I made, where we're engaged in the litigation space, we're also thinking in the policy space of what's the vision of the future that we want. And of course, there's like a policy design piece of that I do a lot of work on, but there's also a legislative piece of that. So that's, we're definitely active.
And Megan, is your new organization going to be working on legislation, model legislation?
I'm a little shy on the legislation piece of things at the moment. I'm hopeful that will be a more positive exercise soon, but we're doing a lot of thinking about what you would do under a slightly different presidency under existing authorities in the future.
Great.
First, thank you so much for the work you're doing right now. My second question, or my question is, how much are we catching? You're combing the Federal Register, you're looking for those rollbacks, you're all working as hard as you can work. What percentage of these destructive rollbacks are we able to fight off in court? And secondly, when Lissa was talking about being more proactive down the road to actually require the agencies to do their jobs instead of spending all their time rolling things back. I remember hearing about budget cuts and things like the EPA, maybe BLM, I don't know, Fish and Wildlife Service. How much of their jobs can they do given budget cuts and other constraints on staffing?
Okay, two-part question. So how are we catching all of the actions?
Like Google alerts and automatic. I get so many emails every day, but I get alerts from all the courts, from the Federal Register. So, we and all of our partners are constantly checking all of that stuff. The question then becomes, what do we actually sue over? There is much more happening than I think probably can be taken to court, and so we work very closely with EDF. We work with the states to make sure that we are deploying our resources the best, most strategic way to stop the worst of the rollbacks, and then spreading out to, take care of things here or there that don't need the full coalition. And so it's a lot of strategy about who covers what and what really needs to be fought versus what can kind of wait until we have a chance, basically.
And maybe Megan, as a former federal official, can you speak to the Trump budget and the
Yeah,
cutbacks?
the budget threats have been worse thus far than their actual enactment. We haven't seen massive reductions yet. That's, yet. What worries me a lot is that they are losing technical expertise, scientific, engineering, legal, people who've been there for decades and are leaving. And that is the kind of expertise you need to put together very strong regulations that are based on what actually works and how can you be as innovative as possible to make things as workable as possible for industry while also getting to the public health result, environmental result, safety result, whatever it is that your mission as an agency is. And I am really worried about that.
Okay, Alice says one more question. There's a hand. Yes, Bob.
Are there any policy or regulatory changes in the natural resources and environmental space that any of your organizations find acceptable or tolerable?
So,
Peter has an answer.
yeah, I mean, I can take that. I think, speaking from EDF, we've always been willing to engage, for instance, on the oil and gas rules, on making them more workable. One of the particular things that I spoke about is this pathway for innovation. How do we make that actually work better? The challenge is we're in a place where we're not having that conversation. We're in a place where the conversation is about eliminating the standards, so it makes it very difficult to think constructively about what more we can do. I'd very much like to get to that place, and I think we're willing to, but I just don't think we're there.
So I think you intended to get a laugh with that question. I think if you look at what was happening under the Obama administration, for example, there was a huge emphasis on cost effectiveness, on flexibility. I mean, agencies bending over backwards to try to use their authorities in ways that would be as workable as possible while still getting to the environmental benefits. And there's a lot of hope as technology evolves that you can keep doing that in really interesting ways. So methane is a great example of this. If we can get to the point where we have continuous emissions monitoring that is super cost effective, that makes everyone's lives better. We can figure out where the leaks are. We can do it without significant cost. We can do it without somebody going to that site and checking everything all of the time, which costs money. So like figuring out how to do that kind of innovation is a tremendous, tremendous thing that certainly everyone up here is very interested in engaging in. That is not what is happening at this moment in time.
Shall let that be the final word?
All right. Let's thank this panel. Thank you all so much. So remember, you all promised you're going to be back in here at 1:15. So lunch is upstairs. There's lunch provided. It's up one floor, but basically right above where we are. And the restrooms, just so you know, on each floor are way